125 assigned before your lordship. My lord, interim order expired during vacation. They were kindly extend the interim order. Like I've been given notice.
My lord, in this matter, I am appearing on behalf of the respondent.
Okay, let the matters be called on. Rising, I shall extend the interim order. You are for the respondent.
Yes, my lord.
Yes, you are for the respondent. Okay. 125.
Lordship, may I be correct? Mention a specially assigned matter to Lordship. The matter was fixed on 4th of May. A time was fixed for your Lordship, and the interim order passed in this matter is expired on 5th of May, Lordship.
Anyway, after vacation, it will appear in the list. Anyway, if the records are here, it will appear as to be mentioned.
Lordship fixed on 4th of May at 10:30 p.m. So, Lordship, because
No,
next door code is fixed on 18th June, Lordship. So, any date before that. So
definitely. On the reopening date, if the records are here, it will be listed either on 8th or 9th. Just a minute, just a minute. Yes.
May I permit to mention an inclusion, my lord? Application, my lord.
Yes, all after 2 weeks.
My lord.
Yes, yes, after vacation, 2 weeks after vacation. Yes.
Okay.
No, was the matter hard? Okay, to be mentioned on 9th.
My lord, may we permitted to mention one matter? This is a legal aid matter, my lord. The interim order is expiring today, my lord. It was fixed on 7th of May, my lord. However, it has not been taken up.
Anyway, on the reopening, the records area on the reopening date, it will appear either on 8th or 9th.
It will expire on today, my lord.
Yes.
It will expire on today, my lord. The interim order will.
What was the interim order?
To stay of the execution of the eviction shoot order.
Anyway, but interim order is there. Okay, so
the order will expire on.
No, but when is the next date fixed before executing court?
That I do not have the.
Anyway, courts will remain closed for 1 week. Okay, the trial, the district court. So it will not be a problem. On 8th or 9th, it will appear. You remind on 8th or 9th. Calculation. Anyway, to be mentioned, either 9th or 10th, whatever it is. Give it, it will appear.
Item number 20.
Either 8th or 9th, whatever it is.
Item number 20.
Just a minute, just a minute. Yes.
Item number 55 of today's list.
50.
55. 55.
Yes.
Well, it is to be mentioned matter. Well, I'm saying I shall prefer for extension of time to take. Can you take up to the before taking
item 55 before rising at 12:30 or something mentioned.
Yes.
Item 55. Mark.
My lord, I'm extremely sorry to trouble, my lord. On the last day, my lord, 4 applications, my lord, stay affidavit of service, they are ready. If my lord is kind enough to take it up anytime today, my lord.
Today, oh, matters are appearing.
Yes, 70, 72, 78 and 80. Only first time stay matters. It won't take more than 2 minutes of, not even 2 minutes.
Okay, item 70.
70.
Then
72, 78 and 80.
Okay, at 12:15.
I'm grateful, my lord, deeply obliged.
Same pair, item number 73 and 74. Same pair. First time appearing, this service is ready, my lord.
Okay, 73 and 74. Okay, then that matter, the item 55 is for what?
For extension of time to.
Okay, let it be taken up at 12:15.
Yes, my lord, I shall.
Yes. No, item 12 and 13. Yes, 112. What is the matter? Oh, 112 and 13. Oh, anyway, but today is not the civil revision day. Actually, there is no indication in the list. Let it be taken up after vacation. For 1 day, you will not suffer. Either 8th or 9th, it will be taken up. Let it mention after vacation. Yes.
Allowed to mention,
okay. Yes, what? 100? Okay. Anyway, after vacation. Yes.
My lord, may keep it after vacation, my lord.
Yes.
My lord, keep it in the to be mentioned list, my lord. Kindly.
But it is either on 8th or 9th, it will appear. If it does not appear, you mention. and get the intimation about the next date before the trial court.
May I have your lordship's kind leave, my lord, to mention, my lord, a Jalpaiguri circuit bench matter. My lord kindly recalls, my lord, these are the matters where, my lord, two matters were taken up analogously. And, my lord, they were made CAV. Subsequently, my lord, one of the petitioners in one of the matters, my lord, had filed an application for recall. So I was humbly praying, my lord, if your lordship can kindly take up the matter anytime, my lord, after vacation, if your lordship kindly fixes up a date.
The slip, either it will be taken up on 10th.
I'm so grateful, my lord.
Lordship, one matter, Lordship, the connected appeal of this appeal was heard out and judgment was also passed. But Lordship, this matter was not heard out. So Lordship, kindly fix a short date, Lordship. Only Lordship, short point
You
is
will let it appear as to be mentioned on 9th.
9th.
আরে ওদিকে যান না দাদা, ঘুরে যান না, কোথায় যান?
এই তো এটা দিয়ে আসুক না
Petitioner, আমি sense নেই না। মানে একদমই সেন্সটা চলে যাচ্ছে আস্তে আস্তে।
for the applicant.
Yes. Thus, this appeal FMA 2932 of 2015, judgment and award dated 19th December 2014, passed by learned additional district judge, 5th court Barwan, presently Purbo Barwan, in MSC case number 37 of 2013, stroke 231 of 2013 is set aside. The appellant's claimants are entitled to compensation of rupees 20 lakh, along with interest at the rate of 6% per annum from the date of filing claim case till today. The respondent number 1 National Insurance Company is directed to deposit rupees 20 lakh along with interest at the rate of 6% per annum within 8 weeks from the date of communication of this order. The appellants will be entitled to withdraw the compensation upon compliance of necessary formalities.
I'm
Grateful, my lord.
Do I appear for the appellate?
Lordship, I am appearing for the respondent, Union of India.
Yes. Hence, this appeal FMA 894 of 2018 stands allowed. The judgment and award dated 8/2/2017 passed by Learned Railway Claim Tribunal, Kolkata bench in claim application number so-and-so is set aside. The applicant is entitled to compensation of rupees 4 lakh along with interest at the rate of 6% per annum from date of filing claim case till today. Such payment shall be made by making the deposit before Registrar General, High Court, Calcutta within 8 weeks from the date of communication of this order. The claimant appellant will be entitled to withdraw the compensation upon compliance of necessary formalities. Yes, hence this appeal FMA 51 of 2023 stands allowed. Judgment and award dated 5th July 2017 passed by Learned Additional District Judge, 6th Court, Paschim Medinipur in MSC case number 488 of 2010 is set aside. The appellant claimant is entitled to compensation of rupees 5 lakh from respondent number 1 National Insurance Company Limited along with interest at the rate of 6% per annum from date of filing of claim case till today. The respondent number 1 shall deposit rupees 5 lakh along with interest before Registrar General, High Court, Calcutta within 8 weeks from the date of communication of this order. The appellant claimant will be entitled to withdraw the compensation amount upon compliance of necessary formalities.
The order will be approved.
Yes, yes.
Time for the applicant.
Hence, this appeal FMA 698 of 2023 stands allowed. Judgment and award dated 15th day of May 2023 passed by Learned Additional District Judge, First Track, Second Court, Howrah in MSCC number 110 of 2017 is set aside. The claimants appellants are entitled to compensation of rupees 6 lakh from respondent number 1 National Insurance Company Limited along with interest at the rate of 6% per annum from date of filing of claim case till today. The respondent number 1, National Insurance Company Limited, shall deposit before Registrar General, High Court, Calcutta, rupees 6 lakh, along with interest within 8 weeks from the date of communication of this order. The appellant insurance company, upon making payment, may recover the amount from vehicle owner upon giving the vehicle owner an opportunity of being heard and following the procedures as laid down in the case of National Insurance Company Limited versus Liraza Bibi, FMS so and so.
Deeply obliged, my lord.
I'm grateful.
Lord, I appear for the appellant.
The facts and circumstances, this appeal FMA 271 of 2024 stands allowed. Judgment and award dated 21/6/2016, passed by learned Railway Claim Tribunal, Kolkata Bench, Kolkata, in claim application number so and so is set aside. The respondent railway authority is directed to refund additional 20% surcharge on freight to the appellant amounting to rupees 8,67,595, along with interest at the rate of 6% per annum from date of filing of claim application till today. Such payment shall be made within 8 weeks from the date of communication of this order.
I'm grateful to your lordship. For the meeting.
Yes, hence this application under Article 227 of the Constitution stands disposed. The matter is remitted to the learned trial court to consider and decide the application for injunction filed in title suit number 202 of 2024 in accordance with law upon giving the parties an opportunity of being heard. Necessary steps must be taken by the plaintiff petitioner as observed above on the next date fixed before the learned trial court, and the defendant opposite parties will be at liberty to file written objection to the injunction application. On the written objection being filed and on the report of learned special officer submitted, learned trial court shall dispose the injunction application. The ad interim order of injunction restraining the defendants from alienating, disposing, or parting with possession of the suit property and from changing the nature and character of the suit property shall remain for a period of 6 weeks from the next date fixed before trial court. In the event application for injunction is not disposed within 6 weeks, learned trial court may extend the ad interim order. Upon considering the report of special officer, in the event learned trial court is of the view further inquiry is necessary, the learned officers may be sent for further inquiry and further remuneration may be fixed by learned trial court. In the event learned trial court is of the view that further inquiry is not necessary, the special officers shall be discharged. As the injunction application is to be decided by the learned trial court, no fruitful purpose will be served by keeping the appeal pending before learned district judge, second court, Shialda, South 24 Parganas, being Miss Appeal 61 of 2024. Thus, the said appeal is treated to be disposed. It is, however, made clear that this court has not gone into the merits of the suit and all points will be kept open. All interlocutory applications stands disposed. Yes, hence this appeal FMA 1016 of 2025 stands disposed. The judgment and award dated 24/5/2016 passed by learned additional district judge 4th court Jalpaiguri in MSC case number 165 of 2011 stands modified to the extent that respondent number 2, Bajaj Allianz General Insurance Company Limited, shall pay the appellant rupees 2,08,750 along with interest at the rate of 6% per annum from date of filing of claim case till today. The payment shall be made by making deposit before Registrar General High Court Calcutta within 8 weeks from the date of communication of the order. The appellant will be permitted to withdraw the compensation amount upon compliance of necessary formalities. Hence, this appeal FMA 1309 of 2025 along with Court 96 of 2025 stands disposed. Judgment and award dated 28th July 2022 passed by learned Additional District Judge 3rd Court, Paschim Medinipur in MSC case number 513 of 2013 is modified to the extent that claimants respondent number 1 to 3 are entitled to rupees 53,50,000 from the appellant Oriental Insurance Company Limited along with interest at the rate of 6% per annum from 17/7/2017 till realization. The appellant insurance company shall deposit before Registrar General High Court, Calcutta, rupees 53,50,000 along with interest within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is already deposited, no further deposit be made. The claimant respondent will be entitled to withdraw the compensation as observed above, along with accrued interest, if any. Balance amount along with accrued interest, if any, will be returned to the appellant insurance company. The claimants are entitled to withdraw upon compliance of necessary formality.
I'm deeply obliged, my lord. Grateful.
Hence, this appeal FMA 1351 of 2025 stands dismissed. Judgment and award dated 19th May 2023 passed by learned Additional District Judge Fast Track Court, Durgapur in MSC case number 62 of 2019 stands affirmed. The claimants respondent number 1 to 3 are permitted to withdraw the compensation amount if deposited in this court. In the event it is not deposited, the same be deposited within 8 weeks from the date of communication of this order.
Grateful, my lord.
In this matter, I am for appeal. 11.
Hence, this appeal FMA 1766 of 2025 stands disposed. Judgment and award dated 30th July 2025 stands modified to the extent that the claimant appellant is entitled to rupees 32,65,200 along with interest at the rate of 6% per annum from date of filing of claim case till today. The respondent number 1, Bajaj Allianz General Insurance Company Limited, shall deposit before Registrar General High Court, Calcutta, rupees 32,65,200 along with interest within 8 weeks from the date of communication of this order. In the event compensation awarded by learned trial court is paid, balance amount be deposited. Claimant appellant will be entitled to withdraw the compensation amount upon compliance of necessary formalities. We will call the contempt application.
Well, may I please, Your Lordship, I am for the petitioner. My lord, here.
My lord, I am appearing on behalf of the respondents from 12 to 16, my lord.
I am for 14.
So you appeared on the last occasion.
My lord, and submitted before this honorable court that the appeal is pending before the honorable division bench. That appeal has been, all the appeal has been dismissed. My lord, I cannot. Not dismissed, disposed. It become
Any order is any order
varied.
varied.
Order dismissed.
Any order is varied. Is this trial court's order?
No, my lord. My lord, we intend to comply it before my lord Justice Kaushik Chandu. We have already made a submission. Matter has been fixed 3 weeks after vacation for compliance because my lord, this is all India basis. My lord, it will be taken. Steps will be taken.
Item number 12 to 16.
12 to 16.
Yes, record an order. Learned advocates for the parties are present. Learned counsel for the contender respondents submits that his clients are ready and willing to comply. The order passed
On 3rd October
on 3rd
2025.
October 2025.
Right.
Stop. But sometime be granted for necessary compliance. In the facts and circumstances, the matter stands adjourned till
Will you kindly give after 3 weeks because those matters are fixed after 3 weeks before.
26, 26 2000 26 26 6 2026
June.
for
It's
submission
I
of
think 26 is the holiday.
26th. In our calendar it is not a holiday.
Yes.
Festival, that's why it's not very.
So 19th, shall I keep it on 19th?
June.
Will it be possible?
Milord will keep it at 19 because we will at least bring with some
Now
status.
calendars are shows that
19 means you see after 4 weeks.
Yes, my lord. Your lordship kindly place it after
19
90.
6 2026
yes.
for submission of compliance report.
My lord.
Wait, this is the kindly give a direction for last chance
No,
because
they are ready.
My lord, we are trying to comply. This is an all India basis.
I've recorded that they are ready to comply.
they are
If you are
ready to comply to issue the appointment letter to the candidates who are appearing before the Honorable
Whatever it is,
Justice.
the order has to, they are ready
Your
to.
lordship's order is prior stage. They have not even considered as a medically, my lord, physically efficiency
Let us
test.
see the compliance
Yes,
report. Okay.
My lord, in the meantime, my lord, two
Whatever
steps
step
they
they will-
have to comply with. That's why, my lord.
No, no, I have directed. They have stated they will
Yes,
comply.
yes, that's
Yeah.
right. We want your lordship's order will be fully complied with.
Yes.
Okay. Deeply obliged. No, in the meantime, they will come.
I'm for 49.
12 to 16, same orders.
Same order, my lord.
Same order.
Separately same order.
Yes, my lord.
নামগুলো রেকর্ড করে নেবেন।
নাম দিয়েছি
I have given it in the chat, my lord. I have given it in the chat.
ওকে ওকে
মেডিকেলটা করা হবে তখন হবে আরে হবে কোন কালের অর্ডার জজ সাহেবের ভেকেশনের অর্ডার আরেকটা ভেকেশন আসতে চললো
Yes, call 17.
17, your lordship, I'm praying for not today. Your lordship.
Okay, not today.
Grateful, your lordship.
Eighteen. Yes, not today. ডেকে যান ও আচ্ছা ঠিক আছে দেখুন ঠিক করুন আগে
যদি লাইনটা ঠিক হয় শুধু ওই এক্সটেনশন করা দেওয়া হবে।
and
27,
পরপর ডাকো না তাহলেই তো
38,
প্রমে হবে না
okay, so anyway, to be mentioned the matters are called. Thereafter, I shall take up that fixed matters. To be mentioned, ডেকে দিন প্রথম থেকে. Yes, 2021, record and order. Learned advocates for the insurance company is present.
I'm for the, my lord, the.
Learned advocates for the parties are present. It is submitted by learned advocate for the for Bajaj Allianz General Insurance Company Limited that the check, which check, compensation check,
Yes, my lord.
that the compensation check could not be deposited within time due to certain difficulties. Thus, the time to deposit the check stands extended till 9,
1 week after vacation,
anyway, 9/6.
if the order is not uploaded. 1 week after vacation.
Extended till 12/6/2026.
My lord, my lord, my lord. Deeply obliged. Grateful, my lord.
Next, not today. Yes.
24, 24.
24, you are for?
I am for the petitioner. I am led by Senior Advocate Pradeep Kumar Roy. Kindly fix,
Okay, I am making it not today.
kindly fix the date 1 week after the vacation.
Let it be not today. After the vacation, I shall fix a date.
Grateful.
Yes, item
25, I want to withdraw the mallet, the non-prosecution of that. This is my instruction.
learned advocate called the appellant submits that his clients are not interested to proceed with this application with the appeal, and he has instruction in this regard.
Yes.
Stop. Learned advocate files copy of the written instruction of the appellants. In the facts and circumstances, SA 16 of 2017 stands dismissed for non-prosecution. Interim order, if any, stands vacated. Let the copy, the instruction filed be kept with the record. Yes, not today.
27, my lord, is again for extension of time, my lord, to deposit.
27 ওই 20 আর 21 এর যে অর্ডারটা হচ্ছে ওই অর্ডারটাই করে দিন।
I'm extremely grateful, my lord.
27 এ 20 আর 21 এ যে অর্ডারটা হচ্ছে ওইটাই। হ্যাঁ 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 yes yes give your names.
My lord, I mean,
হ্যাঁ
27 এ Rajesh the appellant, আমি appellant, Mr. Bonik is on behalf of.
both parties আছে নামগুলো দিয়ে দেব।
I'm extremely grateful, my lord.
My lord, in this matter, I am for the appellant.
Yes. So paper books are ready.
Yes, already. Paper book has already been filed, and I have received that paper book and all.
So who is appearing?
Department has already issued the notice, but respondent has not it appeared.
Okay, let this matter appear on. Let it be not today. After vacation, I shall fix a date.
Yes, madam.
If the other side is there, you intimate the other side.
No one appeared.
You are certain? Who is appearing? দেখুন না আরো কয়েকটা আছে টু বি মেনশন গুলো শেষ করে দিন কল করে টু বি মেনশন আর কিছু আছে কি না 38 কল করে দিন সবগুলোকে কল করে দিন Okay, 29 not today.
I'm applying for the respondent, so I've already filed the paper book. Mr. Singh,
My lord will fix up a date if my lord so desires.
Learned advocates for the parties are present. Let this matter appear on. Let this matter appear on day 11/6/2026 at 10:30 a.m.
My lord, grateful, my lord. 30 থেকে 33 11/6
in item 32, I am filing the paper book. In 30,
let the paper books filed be kept with the record.
Your Lordship.
Lordship, 34, 35, 36 are all identical to us. They are tagged together. Mr. Debanjan Mukherjee is appearing on behalf of the appellants in this matter.
Okay, let it appear after vacation. Thereafter,
I am praying for a not today.
yes,
Much
34,
obliged.
35, 36, not today. Yes, next. Anyway, after vacation, I shall fix a date.
38, my lord, is again for deposit of check.
Okay, 38, ওই item 20 আর 21 এর যে অর্ডারটা আছে ওইটা করে দেবেন। Okay, not today. Not today. Same, not today.
47.
Yes, 49 you are appearing.
My lord,
49.
let it be not today, my
Okay,
lord.
not today. Yes, 55.
55.
Yes.
Extension of time to deposit check.
That is the compensation check.
No, my lord, it's a.
Oh, that security.
Yes.
As a learned advocates for the parties are present, learned advocate for the appellant insurance company submit that the check, that the security amount check could not be deposited within the time fixed. Learned advocate prays for extension of the time to deposit the check. Thus, time to deposit the check stands extended till 10.
No, my lord, may I tell you, lordship, my lord, kindly make it, my lord, 3 weeks after vacation because the check is going to expire on 26th of this month, my lord.
Time to deposit the check stands extended till 19.
Very well.
19. 19. Okay. Let it deposit stands extended till 22/6/2026.
26. Very well. Grateful to you.
56, 57.
Yes.
Mr. Paul is appearing for the appellant. There is only issue of one term. Can you fix any date after vacation? Any date, last lord.
No, who is appearing?
Mr. Paul is
Yes,
appearing.
yes.
Any date 2 p.m. Any date, lord.
Learned advocates for the parties are present. Let this matter appear for hearing on 15/6/2026 at 10:30 a.m.
Not 2 p.m. lord.
At 2 p.m.
Date fixed on
15.
2 p.m.
Not today.
59, my lord, I am for the appearance. Chandri Alam, my lord, other side. Lordship is fixed the date on 12 earlier with the presence of the Chandri Alam. My lord.
So let it be. I shall fix it in her presence on the next day.
60, my lord, not today. 11, but fix the date, my lord, at 2 p.m. or 2. Other side Chandri Alam.
No, it's better to fix it in her presence. On the next day, it will remain in the list. I shall fix
60, not today.
Okay, not today.
62, my lord, is for extension of time, my lord.
Okay. To deposit
I will be depositing.
security amount or compensation check.
This is, my lord, security amount after stay.
Learned advocates for the appellant insurance company is present. It is submitted by the learned advocates for the appellant that the security amount check could not be deposited due to some difficulties. Thus, the time to deposit the security amount stands extended till 12/6/2026.
My lord, my lord. Next one is same. 63 is same.
63, same order.
After stay.
Okay.
Same order?
Same order.
Kindly record that paperwork file in kept in record. And lordship fix
Let the paper books file be kept with the record.
And lordship kindly fix any date.
Oh, this is a 2026 matter. You just wait.
Lordship. Liberty to mention.
No. Yes. You mention it. Okay. I shall take it.
64 is also same.
64.
Same as 62 and 63.
62 and 63. 64 is same order.
Same.
64 same order. 62 and 63.
I'm extremely grateful, my lord.
Okay, thank
Deeply
you.
obliged.
Let's call item number 80. 80. Huh? Okay, 70.
Item number 70, my lord.
Yes.
This is coming up for the first time. Affidavit of service is the
Lordship, in item 70, I have instruction to appear on behalf of the claimant respondents. The copy of the application be served upon me, Your Lordship.
already
Payment of
shall
stay.
serve again.
Lordship,
The affidavit of service.
Article 26 has not been served, Your Lordship.
Yes.
My affidavit of service is there, my lord. I shall once again serve upon him.
And
There is no section 5.
There is section 5, my lord.
Section 5 you have
I
received.
have not got section 5.
I have.
I have only got the copy of the stay application.
So it's better I take it up on the reopening date.
My lord will kindly see my affidavit of service. I have served. I shall once again serve a copy upon him.
What is section? Yes, section 5 is can 2.
Yes, section 5 is can 2.
Yes, learned advocates for the parties are present. The application for condonation of delay is taken up for consideration. Hard learned advocates. Upon perusing the petition, it appears that the appellant insurance company has furnished grounds for the delay in preferring this appeal. Thus, the delay in preferring this appeal is condoned and this appeal is admitted. Can 2 of 2026 stands disposed. Yes, now can 1.
Can 1 is stay.
Can 1 of 2026. The learned advocates for the parties are present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 18th day of July 2024, passed by learned additional district judge, first track second court, Islampur Uttar Dinajpur, in MSC case number 98 of 2020 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General, High Court Calcutta is requested to invest the amount in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Your Lordship, in connection with this matter, I have also filed one appeal, Your Lordship.
Yes.
That being tagged
Let COT, ওই নাম্বারটা দেখে নেবে না?
FMAT, Your Lordship.
Let FMAT. What is the number?
Your Lordship, FMA 1292 of 2004.
FMAT or FMA?
FMA. It is already FMA.
FMA?
FMA 1292 of 2024.
1292 of 2024 appear along with this appeal.
Your Lordship.
72, my lord, is my appeal. This is my affidavit of service. There is section 5, my lord. Can 1 is my application for condonation of delay. I have served. I shall put in Talabana and return up notice. So it's WC, my lord. My lord.
1.
Can 1 is my.
Learned advocates for the appellant is present. The affidavit of service filed be kept with the record. The application for delay, for condonation of delay is taken up for consideration.
Can 1. This is WC, my lord. My lord will kindly.
Upon perusing the petition and upon hearing the learned advocates, this court is of the view that the appellant has furnished sufficient grounds for delay in preferring this appeal. Thus, delay in preferring this appeal is condoned. Yes, let this matter be placed before the Honorable Division Bench for the purpose of admission.
I'm grateful, my lord.
73 আছে তো 73 74 বলি 73 74 বলেছি
26 আছে
73 74 মেনশন করেছিলাম আমি 73 মানে
76 অ্যাপ্লিকেশনে রয়েছে তো
73 বলেছিলাম
73, yes, who is appearing? It is for what?
There are 2 applications, one for delay and another for stay.
submitting my lord affidavit of service, my lord. They have received my lord deliver item delivered. Okay, 73. The affidavit of service is there. Yes, my lord, and one is my lord, section 5 and canton my lord stay. And I have deposited secret.
আমি সব দিয়ে দেবো
And I have secret my lord 25,000. Learned advocates for the appellant insurance company is present. Let the affidavit of service file be kept with the record. The application for condonation of delay is taken up for consideration. The hard learned advocate for the appellant peruse the petition file. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that the appellant has furnished sufficient grounds for delay in preferring this appeal. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay is taken up for consideration. As you have deposited statutory amount, as the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay, ad interim order of stay of the judgment and award dated (18/3/2017) passed by learned Judge 10th Bench, City Civil Court, Calcutta, in MACC number 474 of 2010 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General ওটা করে দেবেন, হ্যাঁ? Liberty to mention. Awarded sum just statutory. The awarded sum. না না 74 আছে তো 74 আছে same mallet ওই যে বুঝে ও নোট করেছে নাকি কিছু করে বলেছি থেকে আপনাকে দিয়ে দেবো This is what both condonation? Yes, mallet. Condonation, mallet, this mallet. Statutory amount, mallet. You file your affidavit of service? Yes, mallet. Yes, learned advocates for the appellant is present. Let the affidavit of service file be kept with the record. The application for condonation of delay is taken up for consideration. Hard learned advocates peruse the petition file. On perusing the petition file and upon hearing the learned advocates, this court is of the view that the appellant has furnished sufficient grounds for delay in preferring this appeal. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. The application for stay is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay of the judgment and award dated 29th March 2025, passed by learned Additional District Judge from Special Court, EC Act, Barhampur, Murshidabad, in MAC case number 638 of 2015 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest, excluding the statutory amount, within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of injunction, ad interim order of stay shall continue till disposal of this application. But the Registrar General order করে দেবেন liberty to mention.
78, my lord. There is no delay, my lord. This is the
75.
there is no delay, my lord. Only stay.
Learned advocate for the 78 item. For the appellant is present. As this appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be a stay, ad interim order of stay of the judgment and award passed by the learned judge, 13th bench, City Civil Court, Calcutta, in MSCC case number 93 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire awarded sum is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Register General order করে দেবেন. Liberty to mention.
Lordship 79, there's the appeal of Mrs. Paul. I've been one line order, Lordship, paper to filing, Lordship 163A, Lordship. This can be disposed of. Mr. Paul will assist the court.
79. No, I'll take it up after vacation.
Yes, Lordship, kindly take
Yes,
taken up.
learned advocates for the parties are present. Let this matter appear on 10/6/2026 at 10:30 a.m.
Along with Lordship court 30 of 2026.
So this is a 163A.
Yeah, it's 163A. 163A, Lordship.
10 June 2026 along with COT number?
COT 3030 30 of 2026.
30 of 2026.
Then let my stay also be absolute because I have deposited the entire awarded sum before my lord's.
I shall consider on the
My
next
lord,
day.
my lord, my lord.
Lordship, kindly fix it.
Can
That
close
date
half
only-
pay.
I fixed 10th.
Can pay.
10th of June.
10th of June 2 p.m. Lordship.
I've kept it at 10:30.
Lordship 2 p.m. Lordship, kindly.
আচ্ছা জায়গাটাকে 2 PM করে দিই।
I'm different.
My affidavit of service is there, my lord. There is delay in the matter.
Just wait, just wait. 80. This is only for stay.
No, there is delay in the matter, my lord. Can one is my application for condonation of delay?
File your affidavit of
Yes,
service.
yes, I've given.
Learned advocates for the appellant is present. Let the affidavit of service file be kept with the record. The application for condonation of delay is এটা দিন তো can 2টা এই condonation
Can one is my condonation of delay.
can 1টা দিন
My lord, will kindly take my copy. Can one, can two it. Do is 2nd April. Can one দরকার এই যে can one টা নেই?
can 1
নেই
can 1টা লিস্টে রান করছে তো তাহলে ঠিক আছে
My lord will keep my copy.
the learned কি আর বললাম learned advocate for the appellant is present. Let the affidavit of service file be kept with the record. The application for condonation of delay is taken up for consideration. Heard learned advocates peruse the petition file. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is furnished for delay in preferring this appeal. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Can 1 of 2026 stands disposed. Yes. What is the application for stay? Can 2টা দিন?
My lord will keep my copy.
Can 1 তো এটা 2টা দিন?
এই যে
2টা আছে তো? The application for stay filed by the appellant insurance company is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be ad interim order of stay of the judgment and award dated 16th day of December 2025, passed by learned additional district judge, 8th Court, Barashat, North 24 Parganas, in MSC case number 914 of 2023 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court in 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. And Registrar General order kore debe, liberty to mention.
I'm grateful, my lord, deeply obliged, deeply
Yes,
obliged.
call 81.
81, my lord, I'm for the appellant insurance company. It has been filed within time. Only stay can one stay, and I have deposited statutory amount. This is my challan.
Yes, learned advocate for the appellant insurance company is present. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 22/1/2026 passed by learned additional district judge, First Court Asansol, Paschim Bardhaman, in MSC case number 29 of 2021 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest within 5 weeks. Stop. The appellant insurance company shall deposit the entire compensation amount along with interest as directed by the learned trial court within 5 weeks. Stop. In the event the entire compensation amount is deposited within 5 weeks, the ad interim order of stay shall continue till disposal of this application. Ever Registrar General order kore deben, liberty to mention.
Yes, my lord.
Yes, call the 120.
My lord, in this matter, I am appealing on behalf of the respondent.
Okay. Yes, record and order. Learned advocates for the parties are present. There is no time today. The matter stands adjourned till 12/6/2026. The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
My lord, your lordship has heard this matter on 15th. That is for the purpose of the further hearing. Your lordship has directed us to file a written notes of submission on the next day. May I be given the time, my lord, with the fixed date?
Okay. The learned advocates for the parties are also granted opportunity to file written notes of arguments on the date fixed. On the date fixed, you file the written notes.
May I be given the time, my lord?
No, I've kept it on this thing, 12th.
Grateful, your lordship.
Item number 76, my lord.
Yes, 76, it was called.
It was called, my lord, at that time, right, just before.
No, 76 for what purpose?
76, I have filed one application, my lord, for withdrawal of the order.
Actually, that matter cannot be decided in the absence of the other side advocates. Okay.
Other side advocate was.
No, probably that matter was earlier heard.
Yes, my lord.
Anyway, let it remain after vacation. You mention in the presence of other side.
My lord, one humble submission, my lord, for item number 91. The interim order has been expired in the month of April 2026. And my lord, the next date in the trial court is in the June, my lord. So,
91.
91, my
at
lord.
order liken into. Learned, you are for appellant.
Yes, my lord, I'm for the appellant.
Learned advocate for the appellant is present. No time today. The matter stands adjourned
My lord,
till.
if your lordship be kindly fix a date, I will.
Matter stands adjourned till 15/6/2026. The interim order granted earlier stands extended for a period of 5 weeks or till further orders, whichever is earlier.
Grateful, lordship.
Yes, call the original site.
This is my application, my lord. Very unfortunate.
Number 2.
And very unfortunate.
This is not maintainable, but the prayer today possibly can't be granted.
No, what is this application is
Let me
appearing?
move, my lord. It's my application.
CA2 is appearing for the first time.
Yes, but I'm asking for an interim order.
Okay, let me see the application.
Do the matter, my lord.
Event number 2.
Okay.
My lord, he's on the third stage, my lord. There were others who also, my lord, your lordship, before, and that's the same argument, my lord.
Let me see.
Let us do the matter. Yes, my lord, may I just point out? My lord, this is a, my lord, partition suit, your lordship remembers, my lord? A son was not being given his property, my lord, this involves the Salt Lake property.
One remembers Mr. Ratnanko Banerjee had appeared and had opposed before your lordship, my lord. But I'll just show the first order which your lordship had passed. Page 16, my lord. First, kindly comes to page 16. My lord, this application is basically, my lord, for in the nature of, my lord, giving effect to your lordship's order. I could have filed a contempt, but I'm not doing it. No, why should I? Why should I? Aha, Mr. Aha. I have that much in me that I will not go for a contempt against my mother. Now, my lord, kindly cease, my lord. My lord, kindly cease, my lord. Huh? ওটা না তুই যেটা দেখাচ্ছিলিস তুই যেটা দেখাচ্ছিলিস সেটা করে মানে this is the first order your lordship sees application for injunction and in this my lord your lordship had passed an order page 16
Page 16, yes.
page 6 and 7 my lord at page 17 sorry
Yes, page 17.
upon hearing the counsel considering the facts of the case and nature considering the balance is just and reasonable to hear the matter ex parte. That's the only ad interim order of injunction in terms of prayers A and B. Just show the A and B. But at A and B, your lordship will find at page 4 of the petition. But I'm more interested in the next order passed by your lordship, that is at page 19. But this was the returnable. This was the returnable day when, my lord, the defendants, which my Mr. Mitro is also appearing for defendant number 2, I suppose he said. So, my lord, they were all being represented. So, my lord, the contention was always there. My lord, what I am showing your lordship, my lord, kindly sees the page 20 at paragraph, the second paragraph.
Yes.
My lord, I had shown your lordship, my lord, an application which had been filed by the mother against the son, where, my lord, they had said that I was also in possession of 2 rooms in the said property at Salt Lake. Now, my lord, just in the second paragraph, your lordship's observation, from the said order itself, it is clear that at present the possession of neither of the parties are disturbed and is to be decided in this suit as to whether the property which is claimed by the plaintiff is co-personal property. Without trial and evidence, this issue cannot be decided. At this stage, there is no scope to modify or vacate the order of injunction passed earlier. So your lordship found that they were in possession, I was also in possession, and will await the trial. Now, my lord, from yes, that is the finding. My lord, and then yes, my lord, I will show the Mr. Mitro, please. My lord, it is in their petition, it is the defendant number 2's petition that was accepted in the suit that I was in possession. Therefore, this was passed. Then, my lord, they went up in an appeal from this. Appeal dismissed. 2 appeals filed, both dismissed. Now, my lord, what am I asking before your lordship? My lord, kindly see page 22 once. That's the appeal court order. My lord, kindly see page 22. 2 appeals are taken up for analogous hearing. First appeal is directed against the order dated February 6th. That is your lordship's ex parte ad interim order. The second appeal is directed against the order of 20th February, which I showed your lordship, where lordship had found that we are both in possession. Now, my lord, kindly sees next page 23. When there were submissions, he referred to the pleadings. And lastly, my lord, the last paragraph at page 23.
Yes.
Parties to the suit are related to each other and are of the same family. There are numerous businesses
Yes, page
involved.
23, which paragraph?
Absolutely, the last paragraph, my lord. This is the observations of the division bench, my lord. Parties to a suit are related to each other and are of the same family. There are numerous businesses and immovable properties belonging to such family. Independent income of the appellant is not established. Concludes at this stage for us to return a finding. The lease of the solid property was obtained by the appellant through her own income. Then, my lord, what is canvassed as a source of income is the appellant. And the next paragraph, in absence of the court being capable of returning conclusive evidence with regard to the source of income, improper to hold, involved cannot form a part of the suit for partition. Issues written by the appellant are kept open to raise the trial. And we find that the learned trial judge exercised discretion in granting the interim order as noted above. Now, my lord, your lordship had refused the vacating finding, the oral vacating, my lord, by finding that I am in possession. Now, my lord, let us see what has happened, my lord. But I am not being allowed entry into the property first. Second, my lord, there were 2 rooms where I was in exclusive possession. My lord, those were locked. Now, my lord, I have got information that they have opened up that room and they are not allowing me ingress egress. But I have come before your lordship only for an injunction at this point that you cannot prevent me from entering because it's a till it is decided in the trial, my lord, it is a property which is, my lord, jointly held. And they had admitted that I'm in possession. I'll just show that document for once, my lord. My lord, kindly comes to page 25. 25 of the petition, my lord. My lord, this was there, 144 of the CRPC, my lord, as it was earlier, my lord. I keep forgetting the new section, my lord, sorry. Yes, my lord, 163(2) of the BNSS. My lord, this is by Uma Saraf, who's the defendant number 2. And Gautam Saraf is a party, my lord, the plaintiff. And the son and daughters are also parties, my lord. Daughter-in-law, sorry, my lord. Now, my lord, kindly comes paragraph 4, page 26.
Yes.
Separate accommodation. Separate accommodation. Yes. Now, my lord, that your states that your petitioner had owned the scheduled property, being the lessee, the governor of the state of West Bengal. Initially, petitioner used to live with her husband along with the eldest daughter, namely Joyasri, and younger son, Gautam Saraf. Then, my lord, kindly comes paragraph 5, that your petitioner states opposite party number 1 got married to the opposite party number 2. Now, the plaintiff, my lord. In the year 2001, since after the marriage, he used to reside in the schedule mentioned property, which is the CL block property, my lord. Then, my lord, they went to Dubai. And, my lord, kindly sees para 5, returned after 2 years, and then again went on living there. The use of and, my lord, the whole family, my lord, is the petition.
Regarding your position, which paragraph?
Yes, my lord. My lord, kindly sees page para 4.
Para 4.
Para 5, sorry.
Para 5.
4 says that I used to live there from the very beginning. Gautam Saraf. Well, kindly sees 4. Initially, petitioner used to live with her husband along with her elder daughter and younger son, Gautam Saraf. I am the plaintiff. Para 4. Then para 5. Petitioner says that her younger son, that is the opposite party, got married with the opposite party number 2. After marriage, used to reside in the schedule mentioned property. But the question is, my lord, your lordship's finding that has today become binding on both the parties. That I am in possession, they are also in possession. They have preferred an appeal, that has not been touched. Now, kindly see, my lord, in paragraph 8, now, my lord, kindly see paragraph 8 at page 28. Last 4 lines. It is to be stated that both the opposite parties intentionally padlocked the rooms at the first floor. So, I was in possession, or else how could I have padlocked it? For establishing their physical possession. Now they say it's absolutely illegal, but how do they say that? Establish that I am in possession. They are wanting that it's illegal. They had filed a suit, they had withdrawn the suit. And now, my lord, kindly comes to my lord, kindly sees what they are trying to do. Page 30, sees the prayer, my lord, the intention. The mother to her son to restrain the opposite party members from entering into the property. Now, my lord, kindly comes to page 31.
Yes.
My lord, kindly sees, my lord, page 31. This is the report filed with regard to that 163, my lord, the 144, my lord, police report. My lord, kindly sees in the course of inquiry, my lord, that is the second sentence, paragraph. I had talked with both parties. Petitioner claimed that she is the owner of plot and surgeon and also claimed that she has relevant documents in respect of it. On the other hand, 14 September, OP member SI number 1 tried to enter the scheduled property, but the security guard posted there stopped him.
Opposite party means your client.
Yes. That's the plaintiff. Opposite party number 1 is the plaintiff, preventing his entry into said property. Then they contacted Bidhan Nagar East. Now, my last paragraph, in course of local inquiry, it has been also learned, dispute has cropped up with the petition and OP members over the issue of possession of the above property. Now, my lord, kindly sees page 32. My dear lordship members, there was a suit also filed by them against the plaintiff. And kindly sees the order here. My lord, just takes the third paragraph, which starts with considering all these. Has the lordship got that, my lord? It appears that the instant suit for declaration injunction, along with an application under order 39. The point of condition injunction is that the plaintiff is a licensing in suit property granted by the government in her favor. Given numbers 1 and 2 are sons and daughter-in-law of the plaintiff. Both the defendants are permitted to stay in 2 rooms of the suit property. This is their case. Malad got that, Malad? Both the defendants are permitted to stay in 2 rooms of the suit property, but they are permanently residing in Gurgaon and are threatening to a plaintiff to execute a deed of gift in their favor. So this is the mother saying, Malad, that I was in possession, I'd gone to Gurgaon, and Malad has seen. The police has also found that when I tried to enter, they stopped me. Now, Malad kindly sees the last paragraph at page 32. There is no appeal to this, Malad. Malad, it starts with considering the contention of the instant application. Has the lordship got that, Malad?
Yes.
Malad kindly takes the 5th line. Therefore, it is clear. Malad has got that, Malad?
Yes.
It is clear that the title of the plaintiff is not be clouded from the contention of the instant application. It also appears that with permission, the defendants are in possession in 2 rooms of the suit property. In fact, the plaintiff herein does not claim any relief of recovery of possession, which is the best efficacious relief of the plaintiff. So, Malad, today, let us say I'm in illegal possession. I cannot be evicted without course of law. They don't have any proceedings. 1. Second, Malad, I've shown 2 courts relying on pleadings filed by the mother, finds that I was in possession of 2 rooms. Third, Malad, your lordship's finding, which has been challenged, but there has been no order, interim order. They have not filed any vacating application. Malad, time for filing opposition, the first petition, Malad, had expired in March. They took an extension. It has expired in April. No opposition filed till date. No opposition. And all along I have been waiting for this, that let them file. But now it's becoming impossible. I am just moving around from one place to another in this city. I am the son where I am supposed to live. But I've also made a GD app. Police letter. Now kindly takes Malad, page 33.
Yes.
But we have said there, we tried to enter the house, we were shocked to find the premises under lock and key. Entering to enter the house, we were restrained and physically prevented by security guards, illegally placed by my parents for entering accessing the property. Malad, I've also written about those petitions which I've already shown, Malad. And Malad kindly sees para 8. And after the appeal was disposed of, Malad, I again tried to enter, thinking that now Malad, they would understand. But again, I was prevented on 15th of May, Malad. My room is there. I've pleaded that, Malad, in my paragraphs, Malad. But it has all documents. My wife's complete Sridhan is there. All jewelries are there. I've got information that they've broken down the padlock. My important documents are there because I was not allowed to enter now. And your lordship has found it that I am also.
Your case is you are just simply restrained or that padlock is broken.
Well, now I have information that padlock is broken.
No, not information. Definitely you were restrained.
Restrained, yes.
Breaking the padlock is a hearsay. You have not
Malad,
seen
what I've Malad, kindly see what I've stated, Malad. Para 17, Malad.
Para
17 of my petition. Malad, this was from my Malad, the next door neighbor. Malad, they saw. I got information from them. I've stated that. I've stated that.
Para 17, yes.
Yes, Malad. Malad, we know, Malad, in India, Malad, neighbors are the main knowledge about the other house more than their own house. Whatever it is, Malad. I have got information. Malad, if they say they have not broken, Malad, I must have entry, Malad. Because, Malad, today, Malad, I have been, Malad, irrespective, whether it's a co-parsonage property or not, your lordship has decided that it will be at the trial. The division bench has also held that. Till that time, Malad, your lordship found that I am in possession, this will be decided in the trial. Now, Malad, this is an attempt to make my suit infructuous. And I'm a family member, I'm not someone outsider.
So, on the basis of your complaint,
Malad, kindly see.
Any case has been instituted.
Malad, we have, as I said, Malad, 15th of May, Malad, I've made an application to the local police station, Malad. FIR. And Malad, kindly see page 46 once.
Page 46.
Your lordship will have a better picture, Malad. Malad, this is the first floor room where I am supposed to decide. But most important thing is the windows are open now. Next page, Malad, again another photograph.
Yes.
So, Malad, my entry cannot be prevented. FIR is at page 48 as I pointed out, Malad. Malad, I have been waiting. I have come to you. Malad, it's obviously very sad between the parents and the children, Malad. That's why I've been waiting. Your lordship's order was passed. They preferred an appeal. At least for the time being, Malad, it should have been, they should have adhered to it. But now I don't have any other source. That's why I've come before your lordship, Malad. What can I do? And now, Malad, the sister doesn't say there are 4 people there. But kindly seize my relief, what I wanted, Malad. But at this moment, Malad, I only want injunction restraining from preventing my ingress and egress. Decree. Well, my suit is for partition, Malad.
Notice of motion.
Malad, partition has not yet been allowed. Is he agreeing to that? You want a partition? Malad, eviction. But I don't have an eviction. I don't want any eviction.
But you want access to my house.
Malad, it is his case that I am in possession. Malad, first of all, Malad, my other side has been misled to believe that this is an eviction suit.
Anything else?
Nothing else, Malad. Let him make on the eviction suit.
Kindly take a look at the plain. I'm for defendant number 2.
One is not.
Kindly take a look at the plain. Lordship has the plaint with plaint
Service
service.
to the but the services on record all have been served.
Numbers 1 and 4.
Right.
Mr. Mitra for defendant
number 2, mother.
You are for defendant number
1 and 4.
1 and 4.
Led by Mr. Mukherjee.
Yes.
But I'm led by Mr.
Plaint means is a suit for partition.
Kindly take a look at the plaint, paragraph 38 of the plaint. 38 and 39. Page 22. Page 22.
Page 20.
I think disturbed so much by Mr. Ray that I page 22, paragraph 38.
Yes.
Paragraph 38, that in January 2025, the year and a half back, the plaintiffs and the family visited and stayed at the CL block. However, on 25th January 25, while returning home after visiting a temple, the plaintiffs and their family were shocked to discover that the defendant number 2, in a premeditated and malicious act, had called her brother Sri Madan Mohanka and brother-in-law so and so Kushiram somebody to CL block to assist the defendant numbers 1 and 2 in forcibly evicting and intimidating the plaintiffs and their families. So evicting in January 25, 2025. Kindly come to the next paragraph, paragraph 39.
Yes.
At the last, just above paragraph 40, internal page 24, I think. 24, or should kindly come to the last the last 6 lines of this page of the paragraph 39 at page 24. Lord, you got it, my lord?
Yes.
That on 14th September, Lord, you can see 14th September 25, when the plaintiff number 1 tried to enter the CL block property, the security guard posted there by defendant numbers 1 and 2 stopped him. January 25, he is evicted. September 14th September, he stopped from entering the property. Evicted. That is, with the help of brothers-in-law, he is evicted. And September 14th, he tries to enter, but he's not allowed to enter. Kindly come to the present petition. And then see the prayers. Can you see the prayers? No prayer for no prayer. Also, can you see the prayers in the plaint? Page 29-30. First is preliminary decree. Second is discovery and disclosure. C is declaration, final decree. And E is decree for not to deal with the assets. Kindly come to prayer F. Prayer F. A decree for mandatory injunction by directing the defendants and each of them to hand over possession of the. So, if somebody is living there, hand over possession of the proportionate portion of the above mentioned properties, buildings, and being CL block. That is the property in question to the plaintiffs. It's a form of eviction they are seeking or handing over a possession. That is, their plain case is in 25th January, right or wrong, they have been evicted. September, they were not allowed to enter. And in prayer F, hand over possession. And today, he wants an execution. In a prohibitory form, he wants a decree for entering the property. Now, Lordship, kindly comes to the present petition. Kindly comes to the present. Well, before that, yes, kindly come to the present petition. Before I show something much more damaging, kindly come to the present petition. The present petition, paragraph 11, page 8 of the present petition. And now in prohibitory injunction forms, he wants the execution, decree and execution. Paragraph 11, page 8. In respect of the proceedings filed before the executive magistrate Bidhannagar police station, filed a report dated 21st September, wherefrom it will be evident that the petitioner was prevented illegally by the security guards from posting the premises. So he's prevented in September 21, 2025. In respect of such prevention and obstruction created illegally. So, January, his plain case is that in January he's been evicted, he wants a handing over of possession. September he tries to go, he is resisted twice, once in 14th September, another date. Now, Lordship, kindly come to the police report, which Mr. Ray just now placed. Page 31. The police report. The last 3 paragraphs of the police report at page 31. The last 3, on the other hand, on 14th September 25, OP, the serial number, what is it? This is the other plane, tried to enter the scheduled property. But the security guard posted, they stopped him. And he's saying he's in possession. He's using the property. So I'm injuncting him from accessing. Then Lordship kindly comes, this is not all, kindly come to page 33. 33. His complaint on 15th May. That is the impugned complaint. Now, the impugned complaint, I'm saying why. Page 33, paragraph 2, paragraph 1. That I am the lessee of the property, sole lessee, and mother's property doesn't become ancestral where a descendant son can. But that's a part. Yes, that I am not. That I, along with my wife Sweta Saraf and our children, namely Soumya Saraf and Sohan Saraf, were residing at CL 198 with my parents, Mr. Ashok Saraf and Uma Saraf. Me and my family were in peaceful occupation of 2 rooms on the first floor. Paragraph 2 and 3. Over the past few years, my relationship with my parents got strained due to the hostile environment created towards my wife. Despite several attempts on my part, differences could not be mitigated. Now, paragraph 3, apropos that. Thereafter, when we tried to enter our house, we were shocked to find the premises under lock and key. On attempting to enter a house, we were restrained and physically. So, past few years and then from now, Lordship, what happens? Now, Lordship, kindly sees the sequence of dates. 20th of February is my Lord's order. 20th of February. 6th of February, then 20th of February. This is my Lord's order, which is at page 16. Page 16, which according to him records that he is in possession. Lordship gives a finding that he is in possession, so he should be allowed to remain in possession. That's his interpretation of the order. Page, that is on 20th February. Affirmed on 30th of March. Affirmed by division bench on 31st of March. What happens? Was he staying there? This so-called, my Lord's order nowhere says that that they should be allowed entry into the property. Nowhere says that. Because Lordship couldn't have said when a mandatory injunction to hand over possession is there. Handover possession is there. Somebody who is already in possession will not ask for a mandatory injunction to hand over possession. If he is in possession of his proportionate, whatever, 2 rooms there, why should we ask? So Lordship did not. I know my Lord too well. My Lord would never pass a decree on the very first day and say hand over possession. So that he is allowed to. Lordship has passed an order. Lordship kindly sees my Lord's order, prayers A and B. What is prayers A and B? Lordship kindly see the first page 16. What is prayers A and B which he is enjoying? That is page 16. The interim order which he is enjoying up to the appeal court is page 6. Is page A and B, that is at page 4 of the petition. Page 4.
Page 4.
4.
Of this petition.
This petition. If you set it out. This petition. It's set out. Page 4.
Yes.
An order of injunction be passed restraining the respondents and men agents assigned from dealing with and or disposing of and or alienating and or transferring and or encumbering and or creating any third party right, title and interest in respect of the joint family assets and property as described in Schedule R. One of the properties I admit is this CL 198 solely. Not to create third party rights. Then B. An order of injunction be passed restraining the respondents and their men, agents and assigns from removing and or withdrawing any sum of money, any sum from the joint family estate. And the averment in the present petition is that in violation of this A and B, I am not allowing him to enter and take possession of some portion. His first submission, I can file contempt, but I did not file contempt, which out of love for my mother, I did not. This is a violation of orders in terms of prayer and B. My lord did not. With all due respect to my learned friend, lordship's order is very clear, very clear. And now, lordship, what he has suppressed is when there is lordship knows a doctrine of committee of court. See what happened on 15th May. That's almost 2 months after my lord first passed the order in February, and a month and a half after the division bench order. 15th May, when my husband was away, in the afternoon at around 2 o'clock, my son suddenly arrives with another person. I've got the CCTV footage. Jumps over there's a tenant on the ground floor. He can't enter through the main gate because he's not allowed to enter. He jumps over the tenant's portion, comes in, starts banging on the main door. Entire CCTV footage is there. I'm banging on the main door, asking the door to be opened. Myself and luckily my daughter had come down from Delhi that time. She's here for a week. Now, we hid ourselves in one room, locked ourselves. In case he breaks it, he's going to attack us. But he goes away. Comes back within 15-20 minutes with the police and 4 other persons, all on CCTV. I will put this in affidavit, and this is also record. CCTV. I let the police come in. I show everything. He comes with the understanding that I'm in violation of order of court. I'm not allowing him to enter. I show him the order of court. My daughter shows, and then the police goes away. Doctor comes. Medically, I'm shattered. I'm very old. Doctor report is there, so I file a suit thereafter in the Alipur court, Barasat court, where the property is situated, and an order has been passed, been served on them. It has been served on them by email because order was passed yesterday. And where is the order?
He's talking about committee of courts. He's talking about committee of
where is the order? Yes. This is sent by email also and by post. Email has gone and attachments. So attachments are also.
8/9/2025, there is already an order. 8/9.
No, yesterday, my lord.
Yesterday. After 15th May,
after I filed this application, they take it.
What are you saying? The order was passed. You served the application yesterday evening. The order was passed in the afternoon. Suit was filed day before yesterday. What are you saying? Or kindly sees the order passed. Show me the letter.
The order actually.
The order I've got typed copy of the order. I've typed it down. Lordship. Now give me a copy of the letter. Give me a copy of the letter. Or kindly sees the advocate's letter and the instruction which has been sent by email in the morning.
Bengaluru.
Sent by email to you. I've got the instructions from and on behalf of my above named client, I have filed on 21st May the above mentioned suit against you as the defendant, and also filed separate application for temporary injunction under Rule 100 read with so and so. And upon hearing the said application 21st May, the learned court, after taking due note of the fact that the defendant was trying to deprive the plaintiff of her rights as a lessee of suit property by forcibly taking possession of the suit premises, and further considering the entire facts and circumstances, the documents filed by the plaintiff and the balance of convenience, give a copy of the plaintiff, which tilts in favor of the plaintiff, being of the view that the plaintiff had made out a prima facie case, and for protecting the possession of the plaintiff, allowed the ad interim injunction as prayed for in terms of the observations as above, and directed both parties to maintain status quo in respect of possession of the suit property as on date till the next date or 22nd of June 2026. Or she can see the one more copy of the petition. Lordship, can you see the suit The suit is for, which has been filed day before and yesterday, moved yesterday, page 11, or whatever given it.
No, this is the document with regard to the order passed, right, directing maintenance of status quo with regard to possession of the suit property.
That is the order passed in the suit for injunction not to disturb my possession and disturb my possession and by not and by restraining him from entering my property, which he has not been as per his case from January 25. And this was served by email. And this gentleman lives in Bangalore. He has a multinational job company. That's why he comes back. The order passed in February by my lord. March or February. The order is passed in February by my lord. Affirmed by appeal court in March. He lives in Bangalore. He comes down 15th May and tries to forcibly break into my property. And Lordship sees the medical report 101 of this. My client was seriously unwell after this. It took her 2 days to recover before she could even lodge a police complaint. Choosing a time in the afternoon. Luckily for me, my daughter had come down for a week from Delhi. She lives in Delhi. Choosing a time when my husband will not be there, with a gang of 3-4 people, starts banging on the door. And then police, seeing the sense, did not break into my property. Now, give me the order. Give me the judgment. I want to place. Maybe, I know this is the High Court. Your Lordship is higher court, but Lordship is not exercising appellate jurisdiction over the order. So, Lordship kindly takes a look at the.
Even mention the order of the suit in the plaint.
When get it set aside, Lordship kindly comes to 2007.
That's it only.
Yes, I'll give.
Don't. 75 SCC, page 510. Lordship knows the judgment very well. Paragraph 16. At page 5.
Paragraph 16.
Paragraph 16.
Yes.
The said issue is pending consideration for the Madras High Court. Not only the parties to the agreement, but also those officers who have negotiated on behalf of the respective companies are also parties therein. LG Corporation, which is the owner of the LG logo, is also a party therein. Therein, an order of injunction has been passed. In terms of the said order of injunction, the appellant herein was prohibited from taking any action in terms of the agreement, which would include the arbitration clause. Order has become final. No appeal has been preferred there against. The applicant could have filed an appropriate application for modification of the order of injunction, which it did not choose to do. The doctrine of comity or amity requires a court not to pass an order which would be in conflict with another order passed by a competent court of law. The courts have jurisdiction to pass an order of injunction not only under or 39 Rule 2 of the court, but also under Section 151 there. Now this I will show another judgment of Supreme Court where Supreme Court does not pass because there is a High Court's order to the contrary in another parallel proceeding. Lordship kindly takes a look at 2011 5 SCC.
Yes.
Kindly come to page 638. Paragraph. I could not come here because I am challenging, because I am in the process of filing. It's already been filed. Order 7 Rule 11 for rejection of plaint because according to me in this suit, I am the cause of action doesn't disclose against me because I am a mother and mother's property. Ad interim order is there, cannot be a co-pastoral property where.
Anyway,
Lordship, come to paragraph 78. The doctrine of amity and comity requires the court of concurrent jurisdiction to pass similar orders. In India household, for healthcare, the doctrine of comity or amity requires a court not to pass an order which would be in conflict with another order passed by a competent court of law. Now, Lordship kindly comes to paragraph 83.
Paragraph 80.
Lordship, from then onwards, Lordship, paragraph 83. At the cost of repetition, we once again intend to notice the judgment and order passed by the High Court in WP number 1051 of 1966. The court, while narrating the facts, specifically observes that what is challenged before it by the petitioner was a notification dated so and so issued under Section 7. While dismissing the petition, the court has observed that the petitioner has failed to avail the alternative remedy of appeal provided under the Act, and at the belated stage, he cannot question the correctness or otherwise the notification of 11 December. Therefore, it may not be correct to say that the court has rejected the writ petition only on the ground that the petitioner, without availing the alternate remedy provided under the Act, could not file the writ petition. We hold that the writ petition was dismissed by the High Court not only on the ground that the writ petitioner failed to avail the remedy under the Act, but also on the ground that the petitioner could have questioned the notification. Therefore, in our view, the approach of the division bench was not justified. Which this has nothing to do with the principle of res judicata, or we say nothing. Only holding the thing that when a competent court refuses to entertain a challenge in a writ petition filed, the High Court could not have entertained the writ petition on the same cause of action at a belated stage in the writ petition filed in the year 1990. The course adopted by the High Court could not only lead to confusion, but also lead to. We also hold that the judgment and order of High Court binding on the authorities, and therefore they could not have re-agitated the correctness or otherwise of the notification dated 11th December issued under Section 7. Lordship. So, and also paragraphs 80 and 81, Lordship. So the Committee of Court, Lordship today, my remedy. The property is in the jurisdiction of the Barashat Court, of the learned Barashat Court. So a suit was filed after this incident happened without having any idea that they are going to consider this as a violation of this order. And after that, they are going to serve an application and upon us at around, what time is this, 4:30 yesterday, knowing that telepathically I filed the suit one day earlier and I get an injunction order. I do not have telepathic qualities, so I could not have known. So, Lordship, now, my Lord, may I summarize my points, my Lord? May I summarize my points? Now, my Lord, my first point is that now, my Lord, my first point is that this prayer is overreaching the prayer F in the plaint in the suit. Good morning. Yesterday, after the evening order was passed. What else? Lordship, this is without getting an order in terms of a decree in terms of prayer F in the suit. They cannot ask for and access into the property, where they have admittedly not been in access, have not had access since at least January 2025, rightly or wrongly, and for which they have asked for possession. So access they cannot have. Number one. Number two, the order of my Lord is very clear. Not to treat third-party rights, not to deal with the properties.
So there is no mention in the order that the plaintiffs shall not be dispossessed or plaintiff's position shall not be interfered with. There is no observation in that particular order.
No prayer also.
Regarding possession of the plaintiff.
Prayers A and B. Lordship did not, and they also possibly knew that Pre-ref mandatory injunction decree when you are asking for, you can't at the same time that hand over possession to me. In the meantime, don't disturb my possession. You can't do that. You are asking for decree for handing over possession to me.
Where is that?
Pre-ref, Lordship, kindly take a look at page 3 of the application. The suit prayer is set out.
Set out.
At page 2 of the application, can you see, take a look at the present application, page 2.
That is proportionate portion.
My lord?
Proportionate portion, not so and so, room A and B.
It is pursuant to the partition.
Proportionate portion. Okay.
On
That
partition.
means, that means if they get a proportionate share, that should be handed over.
Yes.
Suppose they get 5% or 50%, and now they're only occupying one room. Okay. 90% is occupied. That what if at all there is a status quo, that should be confined within that one room. Okay.
If at all they were in possession.
Yes, at best that one room must be room.
If your lordship had intended to direct.
At best, you see, there the scope of the court, there is no scope to extend beyond that. Share may be many, 50%, 30%, but room, 1 or 2 rooms,
Only that too.
that is not a share.
That's not a share, very well,
That
lordship.
is a temporary, no, that is the present
Now,
position.
yes. Lordship, now so far as praise A and B are concerned, which your lordship has granted, lordship has said nothing about possession of the plaintiff's possession being not disturbed. And lordship sees the appeal court's order also. There is not a whisper about the possession. Lordship, kindly come to the appeal court's order, pages 23, 24. Lordship, appeal court's order also nowhere said that the plaintiff is in possession or the plaintiff's possession of CL 198 Sorrel Lake should not be disturbed. Neither, because that's not the prayer in the application also. Page 24 is the operative part of the appeal court's order. So the preface of the case that this is in contempt of court. I could have filed contempt, and as if he's doing a great favor.
See,
Yes.
probably in this court's order, page 20, there is an observation that present position of neither parties are disturbed, and it is to be decided.
Yes, not to be disturbed.
No, neither it is disturbed. At that point of time, there was no disturbance of the position.
No disturbance.
At that point of time.
That is the final.
Because Lordship clearly sees, because it's in January, because their petition case is that January 25th January, they were legally evicted. That is what I showed, my lord. That is paragraph. Lordship kindly sees a look at page 38, page 22 of the plaint. Plaint, page 20. Plaint, page 20. Page 22. Yes, page 22, paragraph 38.
Page 22, paragraph 30. Yes, what does it say?
Of the plaint.
Yes, please.
That in January 25, the plaintiffs and the family visited and stayed at the CL block property. However, on January 25, 2025, while returning home after visiting a temple, the plaintiffs and their family were shocked to discover that the defendant number 2, in a premeditated and malicious act, had called her brother, Sri so-and-so, and brother-in-law, Sri so-and-so, to the CL block property to assist the defendant number 2, forcibly evicting and intimidating the plaintiff. Followed by paragraph 39 at page 24, where he says, on September 14,
yes,
2025, when the plaintiff number 1 tried to enter the page,
paragraph 39.
Yes, page 24 of the plaint, the last of the plaint, of the plaint, not this application, but the plaint was made.
Yeah.
The plaint. The last 6 lines of above paragraph 40, page 24.
Page 24.
Of the plaint, my lord. Lordship, the paragraph 40, Lordship was seen at page 24. Just above paragraph 40.
Yeah, paragraph 40, yes.
The last 6 lines of paragraph 39, that on 14th September, when the plaintiff number 1 tried to enter the CL block property, security guards posted there by the defendant 1 and 2 stopped him. So September 14th, he was stopped from entering. And Lordship has also seen in this petition, in page 8 of this petition, he has said, from September 25, page 8 of this petition, paragraph 11. That was September 25, he is not being allowed to enter the property.
Page 8, paragraph 8.
Paragraph 11, page 8. In respect,
Yes.
in respect of the said proceeding before the Land Executive Magistrate Bidhan Nagar, East PS, filed a report on 21st September, wherefrom it will be evident that the petitioner number 1 has been prevented illegally by the security guards posted by 1 and 2 from entering the said CL block property. The report of September 21. And this is affirmed true to his knowledge by the plaintiff. Then he has again said this again, Lordship. He has annexed to this plaint the police report, page 31. Page 31. Page 31. He has annexed this police report of 21st September, the last 3 paragraphs. On the other hand, Lordship, page 31, Lordship has seen, Madam.
Page 31. Page 31, yes.
Page 31, Lordship, the last 3 paragraphs. On the other hand, on 14th September, OP member serial number 1 tried to enter the scheduled property, but the security guard posted there stopped him. And now, Lordship, this is ultimate abuse of process. Lordship sees the abuse of process. He gets an order not to deal with the property. Lordship does not say that his possession should not be disturbed. Whatever possession shall continue.
For the trial, that is the district judge's order is this status quo with regard to possession.
Yes,
should be maintained.
So now he wants to get from what he has not got from January 25. He wants to come and start using. Lordship, can you see the prayer in this petition? This present petition prayer. Present petition prayer. Where is the prayer? In the notice of motion, and order. This is ultimate abuse of process. An order restraining the respondents and their men agents, assigns and subordinates from denying ingress, egress, and or entry in a negative form.
So where does this plaintiff resides now?
It's in Bangalore.
How?
Yes, I will show from LinkedIn address.
Just present position.
Yes, he lives there. Maybe he's come down today.
Now the question is, if he is not permitted to enter, it's not that he will be on the streets.
No, he's
in a
fresh and hearty. Lordship. In fact, his wife has affirmed even in March, showing the address of where in March he has shown that she's been living in some New Aleppo property.
Anyway,
New Aleppo, Lordship, can you see
anyway, this is an admitted position.
Yes, page 49. Page 49. Yes. In the police complaint. Page 49. He is saying here he's affirmed. Page 49. This FIR on this complaint registered. Yes. Present address. Lordship, see at the very top address type. This is the present address of the complainant. Can you see? It starts at page 48. What's the page 48 of this present petition?
The question is, you see, in a year, how many times the plaintiff comes to this Calcutta residence?
He's last tried to forcibly enter in September 25. Then he tried to forcibly enter.
There are no belongings in his custody in any room in that place. Nothing is there.
Well, his belonging.
His belongings must be in his room.
I will give it that affidavit. What if there's anything? If there's some trouser.
Suppose he comes once or twice in a year and resides in this particular room. You see, so what prejudice will be caused?
Well, the relationship has reached a point when it is totally beyond repair. Totally beyond. My clients who are very old, my client, feel intimidated when they come down, and extreme bad behavior. There are several police complaints, those I bring on record, extreme. So it is like having, I mean, should not be that way. The relationship should not be there by whether the son files his case against the mother, father. Mother files as a case yesterday in the Alipur court, in the Parashat court, but it causes just see this in this present suit, Lordship Kelly, Lordship, the new suit which we have filed, kindly come to page.
No, new suits, you see, page. That is not contested. That was the order was passed.
No, what I want to show you is page 101, the medical report. After
that is your document, okay? So
doctor's report.
That will be.
So
that
there
will
was
be
a blood pressure went up. Blood pressure went up.
Is famous.
She had a anxiety attack.
So it's better, you see. These are all interim reliefs. You resolve the matter so that the property is partitioned amicably.
Well, yes. Property is this is not ancestral property. This is the mother's personal leasehold property. Or we can go for mediation if Lordship wants to do that. But then this is a lease. This is a lease. This is admitted position. Lordship takes a look at that the lease is taken by the mother directly in 84. How does it? This is and
anyway, that can be sent to mediation also after vacation.
Yes, but Lordship, kindly do not pass any order today. Give me a chance to file affidavit, because this order today would be something which is altering the status quo, which was not there since long before filing of the suit. Lordship did not grant that order on the first day. They did not pray for it. Just because on 15th May they come and start banging on my door and lodge a police complaint doesn't mean by that behavior he'll be allowed to gain access into my property. This will be beyond the suit. There is no prayer in the suit that can you see the prayers in the suit also? Page 2, page 3, that I should be allowed to reside or my access should be there. Okay, can you see the prayers in the suit? See the prayers in the suit, page 2. It is in aid of which decree is he asking for this relief? Now she kindly takes a look at in aid of which decree is he asking for this relief. Now she kindly comes to page 2 of the.
Anyway, I've seen that.
There has to be some.
The main relief, what is.
What are the main reliefs in aid of which he's asking for? Because if you ask for a perpetual injunction, not to, to allow free ingress, egress, that there is no such relief also claimed. On the contrary, mandatory injunction, whatever proportionate share I'll get, you give it to me in the property. Lordship's interpretation is right. I bow down to my Lord's interpretation. So on partition, if at all this is partible, you hand over possession. But if I am in possession, I would not normally ask for it. But there is not a single averment that I am in exclusive possession of the property.
No question of exclusive. Only 2 rooms.
Well, 2 rooms are not in their possession. Lordship can send a special officer and go and take a look.
I'm not allowed to enter. That's why now.
From January 25, he has not been there.
In his petition, everywhere he says.
So,
but if he has finished, let me.
Well, it's so able. If he's in possession of 2 rooms, there has to be a suit for not to disturb my possession. And a suit for partition, you can't say that you let me go and use the property.
Question is during pendency of the suit, if his possession is disturbed, assuming. So his remedy lies in filing a fresh suit, not coming here.
Lordship, because if this suit is for partition, and if assuming after February 26, he doesn't say when he's been dispossessed. Lordship kindly comes to his averment at paragraph 17, what he's talking about, page 10.
Yes.
Page 10.
Yes.
Suddenly on 16th May, he comes to learn that his possession, he has not been allowed to enter from January 25. Further, on 16th May, the petitioners came to learn through common friends and acquaintances that their 2 rooms in the said joint family house at CL had been unlawfully forcibly broken open. And this will be without affidavits. If he comes, say, once in 6 months and he wants to start using the property, stay there for a week, give me a chance to file an affidavit before your lordship fixes a date on the first week on the reopening. This is some friends tell him, acquaintances tell him that this has been broken open. Who has told him? Which friend? And how does the friend know? Till he gets a partition decree. Lordship knows the law very well. Well, till if one is not in possession, one or not. You get your portion in terms of prayer after the final decree is passed, preliminary decree, final decree. Till then, how can you say that I will be? And when you yourself admit.
Yes, which page is the order of the, I think the earlier order of this court?
Yes, my lord.
Earlier order of this court, my lord, that is page.
Not this court. The probably Alipur court.
Alipur court.
There was an earlier order.
I've shown that, my lord. Just give me a moment, my lord.
Which page?
Page 32, my lord.
Yes, page 32.
My lord, if he has finished, may I give a reply? He's repeating the same thing, my lord.
No, I'm answering my lord's queries.
There wasn't any.
Lordship, page 32. This suit is 8 September 2020.
He can't maintain this suit also. What is he saying?
Lordship, both Lordship, kindly see the third
eviction suit has been disposed of, withdrawn without liberty.
Considering all above, it appears that the instant suit is for declaration and injunction. I don't know where he gets the eviction. It appears that the instant suit is for declaration and injunction along with Order 39, Rule 1 and 2. The bone of contention of the injunction application is that the plaintiff is a licensee. It is a lessee. Respect of the suit property granted by government of West Bengal in our favor. Defendant numbers 1 and 2 are son and daughter-in-law of the plaintiff. Both the defendants are permitted to stay. Okay. And they permitted to stay in the suit property, but they are permanently residing in Gurgaon. If you also read the entire thing, permanently residing in Gurgaon. Permanently residing in Gurgaon, and therefrom they are threatening the baby. So they'll come down, Lordship. They come down every 6 months. If you want to come down, or maybe more frequently, permanent resident of Gurgaon. Now I'm told he's in Bangalore. And now he will come down, cause maybe bring about an early demise. So, and if she dies intestate, and then the property may go to he may get a share. So he wants to come down, stay here. Though he has given the address of 594 New Alipur in the FIR register, 594. Lord Secretary sees the address, 594 New Alipur, not the Salt Lake property. So he's not in any hotel. Not in any hotel. So he comes down, gives his address as 594, that is page 48, 49. 594 Block O, New Alipur. And he'll come every few months. Go in, and just because I had permitted him to stay once upon a time. And Lordship, my submission is, Lordship, a status quo which was prevailing just before the suit can be altered. When his own case is that January 25, he was forcibly evicted. September, he tried to go in, he was not allowed to enter. Assuming that 2 rooms are still lying under lock and key, assuming. But your Lordship can send somebody just now and go and take a look. I also don't know exactly, your Lordship can send someone just now to take a look.
Anyway, let him reply.
Well, I'll just take 2 minutes.
So I want to file the affidavit. Lordship, can you take the earliest date after the vacation?
Well, 2 things.
May I only add, but I appear for before my starts. I appear for different number 1 and 4. I'm the father. But I just want to add one thing that if at this point of time, the possession, as a Lordship knows, could understand the possession is not with the plaintiff of the 2 rooms. Now, we stay. I stay and we and my wife.
It's a vast property, probably. Only 2 rooms.
It's a.
How
it
many
is a-
storied building is that?
Well, I've shown you, Lordship, the picture
That's
is there.
two-story,
Three-story,
ground floor,
two-story.
tenant.
Two-storied building.
Ground floor, first floor, second floor.
Ground floor is a tenanted
I have
property.
Three-storied building.
Three-story. I have got
Ground
two
floor tenanted.
rooms in the first floor.
Your room is ground floor.
In the first floor, 2 rooms.
First floor and half of second floor is constructed. And this is small, less than 4 cut of land in Salt Lake. Not a vast property.
If at this point,
Well, generally when
allow the entry, our lives will be in danger. We are aged people. Repeated attempts have been made by the plaintiff to enter the property. If your lordship has seen, but my learned senior friend has shown. At this point of time, this should not be.
Anyway, let him reply.
Very quickly. Well, today he is now taking recourse to an order passed by a Barashat court. Barashat court. Barashat court has passed an order of status quo according to him. I have not seen the order. The letter says so. First, Malad, let me correct Mr. Mitra once in a while, Malad. There are a few corrections. Malad, this notice has been served on me today at 11:46. So, Malad, I did not know, Malad, so there's no case that I've kept it away from your lordship. And there's no attachment. Second, Malad, in this plaint, your lordship will see they've only mentioned the suit without showing your lordship's order. And, Malad, this point of lessee being the mother, and no one can challenge that right, Malad, has been decided in the intrinsic by your lordship, upheld by the division bench. And this is a clear case of fraud on court. This suit. This is no, sorry. I don't know whether it's your client or others. I'm telling you. Is it you or your client or someone else?
Anyway,
fraud on court. Because they have not shown the order.
Anyway, rightly or wrongly, that order is binding upon all the parties.
No, that's what I want. So what is the order?
Status quo with regard to possession.
Now, my lord, in your lordship's order, your lordship has found that possession of both.
So what was the order? Order was not to alienate.
Injunction, my lord. I'm on the finding, my lord.
Just a minute.
My lord, I'm on, but please, Mr. Mitra, I have not made.
Just a minute.
Please, let me.
Page 16, restraining.
My lord, I'm not on that, my lord.
Yes.
Kindly appreciate. I have come before your lordship on a finding of your lordship's court, which has not been set aside.
Page 20.
Yes, my lord. Which says it's in possession. And they have taken a status quo, and that is the status quo then.
So page 20, okay.
Yes, my lord. Page 20, the last paragraph, from the said order, it is clear that when the possession of neither parties are disturbed, and it is to be decided in the suit. So obviously, my possession is not to be disturbed. This has been suppressed from the court.
At that point of time, the possession was not disturbed.
Yes. So that is what I'm on.
Neither of the parties' possession were not disturbed.
That is what I'm now.
According to you, you may have 50%, 30%.
But I'm not.
But at present, your possession is only confined to 2 rooms.
And my lord, such a long statement is being made with regard to prayer F. My lord, this is a new line of.
The problem is not with regard to 1 room or 2 rooms. The problem is the moment your client is entering, some disturbance are being started.
Lord, where is that, may I ask? Now, your lordship sees.
That is the problem.
My lord, that is what he says. First suit filed, withdrawn by them.
So if you can, no, you see, without going into the merits, if you can assure Mr. Mitro that there will be no disturbance.
I cannot assure him, my lord.
Yes.
But how can I assure him?
So without prejudice.
Yes,
what he's a disturbing character.
Without prejudice,
disturbing, I know.
Without prejudice, that permission can be granted to enter.
Well, let him. Why should I disturb possession?
The stopgap measure, that permission can be granted for the time till disposal.
That is what I'm on. Why should I disturb?
Because there are allegations. You see, whatever has to be decided will be decided on trial. Possession has to be protected. But the moment you enter, different problems start.
I'm not being allowed to enter. That is the point.
That is the reason you see.
Where is that I have entered and have caused problems?
Normally, parents will not disallow their son to enter. But only
not the point, Malad.
Only
the point is there is someone else.
Sister.
That is the sister.
Married sister.
Anyway, after vacation, whatever it is, without prejudice, the matter may be sent to mediation because.
Yes, that can be. I don't have a problem, but Malad.
Your client is now residing where? In Calcutta, in some other hotels?
Malad,
or in Bangalore now?
Malad, if I maybe probably he knows more than my client, Malad.
Please.
And each and every statement is a false statement. Each and every statement.
Because
Malad, that is my in-laws Malad address. Why will I stay in my in-laws place where I have a place? Let the defendant number one go and stay there. That is not the way. That is not the way. Mr. Mitra, that is not the way. And my lord, it's a fraud on court, and my lord will kindly not support a fraudulent person without mentioning any of the order. And my lord, what is he saying, my lord? My possession, which I have sought for in the suit, my lord, is a consequence of the partition. So my possession.
I've clarified that. You may have
Absolutely.
30%, 50%, but now you have confined yourself to only 2 rooms.
Yes. That is what I had. And now, my lord, these two judgments only very quickly, my lord. My lord kindly takes, but I'm relying on this. I'm relying on this. My lord kindly takes the first one, 2011 5 SCC 607 at page 638. Para 78. I'm grateful to my learned friend. My lord, he just handed over, my lord. I'm sorry, my lord.
11.5 SCC.
11.5 SCC, my lord. This is
cooperative housing.
Partition suit. I'm in possession, constructive or otherwise. And then he says that how can you ask for possession? And he goes there, and he goes there. Please, Mr. Mitra, please.
Now this is what I
Let me make my submission.
constructive.
You have finished your submission.
Will become actual physical possession.
Malad has found that I'm in actual possession. Their petition says I'm in actual possession.
Constructive possession.
Says I'm in possession.
So, Malad, if I can ask for possession, that is through partition. And he's saying I've been evicted. Which order is there to show that I've been evicted? What is he saying? That would give me further reason to be in the possession if he can't show any order. Now, Malad kindly sees. Doctrine of amity and committee requires the court of concurrent jurisdiction to pass similar orders.
That is 2011 5 SCC.
5 SCC, page 638.
Page 638.
607 it starts.
It starts at 607. At 638.
Yes, yes.
The other judgment which is referred to is what is being referred in this judgment. So I'm only dealing with this. And he has shown India Household, which was a case in a arbitration proceedings. This says doctrine of committee or amity requires the court not to pass an order which would in conflict with another order passed by a competent court of law. But how? Malad kindly sees this petition. Have they annexed any of the orders?
Suppressed.
Completely suppressed. The copies of the orders. Haven't mentioned about the division bench. Nothing. And Malad kindly sees, Malad, the specific point has been taken that they are lessee. The lady is the lessee, the defendant number 2. And therefore, I cannot have any rights. That has been kept for the trial. Now, my lord, kindly thinks about this situation. If those orders were placed, before this Parashad court, would that order have been passed? Where is the question of committee and amity, my lord? Because this court wasn't says in first.
Failed to obtain orders from Bidhan Nagar.
They failed to obtain orders from Bidhan Nagar. They withdrew their eviction suit without liberty.
Not eviction suit, please.
And today, my lord, they come before your lordship and says, they should have produced these documents. What documents are you talking about? These findings at this interview, even as a matter of fact, 2 days back against Supreme Court has passed, and I couldn't believe that this would be argued, so I could not bring it. I'll give it to your lordship after lunch. But 2 days back, that introductory stage findings are also res judicata. This is your lordship's finding. Have they told that trial court that this was your lordship's finding? And otherwise, my lord, as I said, my lord, if it's a status quo, it reads with this finding of your lordship and gives effect to it. My lord, this is not the way of dealing with.
Question is, you see, it has to be decided
Well,
upon
let it be decided.
affidavits. Okay. Yes. Now the question is only their dispute is with regard to possession, not possession even, entry. Okay. Now the question is that you
allows my entry, I will restrict myself to those 2 rooms.
Yes.
Entry into my house.
Please, Mr. Mitra, again.
Your client is now not residing. Definitely after some days he will return.
That is why I'm saying this.
How long you want to reside in Calcutta?
My lord, I am permanently placed here. What I have been doing, my lord, it is his petition. It is my hometown.
Okay.
But I go for my work. In my own house, where there is an injunction on my pleadings of possession and my partition, I am being told that I will have to visit as a guest.
No, let him say since when has he been living in his in-laws house? Let him say.
Because you see, Mr. Mitro did not get any opportunity to give the place of residence of your client particulars. Okay.
may I say that,
Now
Malad?
he is unable to say
Kindly,
because he did not use any affidavit.
do not give this premium to him, Malad. But he has had 2 opportunities to file his opposition.
No, before this court.
Yes, 20.
Yes.
The first application, not filed as yet.
Did you state that he is creating disturbance
Yes,
earlier?
not filed.
I will.
In spite of opportunities galore, from March they are not filing opposition.
Opposition not yet filed.
No. And they're coming and
It expired last week. It expired last week.
And before
No,
that,
that's the second time.
There's
in the appeal,
there's a
in
change
the
of
appeal court was this point taken that disturbance is created.
No,
Moment-
where is the appeal court say that he's in possession?
Because this is
not taken.
because this submission with regard to disturbance, okay, annoyance and disturbance.
No,
This is your submission because anyway, these were not taken in your affidavit.
Appeal court nowhere said that I am in possession, like in the plaint. It is nowhere about. And that my possession should be.
It was said
Regarding, you see, regarding creation of disturbance and annoyance, the moment Mr. Rai's client enters into his house, that will not find place. Of course, till today you did not file any affidavit in opposition to
That's why
this.
I filed on the reopening.
Okay.
It
So-
expired only.
There is no iota of
But again,
evidence.
Malan, Mr.
Only
Mr.
last week it expired.
The second extension
Only,
which has expired.
only allegation was there before that district court that forcible entry and disturbance.
On that day.
On 15th May, tried to enter
Not
the house
before
for
we press.
like he tried on 14th September.
What
As
Mr.
his
Mitchell
case,
added.
14th September, he said
Right,
earlier he tried to forcibly enter. Now
That's
again
what has been
15th
added.
May tried to forcibly enter. And
Where
now he has himself
Malan,
said
what did he say?
he's in
He said,
constructive
I was
possession.
not allowed
He's in
entry by the
constructive
security guard. That
possession.
was his first statement.
Yes. So
That was his first
he has not
statement.
been allowed.
Well, that itself shows
September.
I'm not being allowed to enter. And I'm here because of that. I've told that in my
Question
petition.
is, you
First petition says that.
your entering means, you see, you may have definitely different residence Calcutta outside.
Don't have.
Your entry is for just to inspect and then go or to stay for few days.
My room.
Valuables are there.
Since when? When did he last stay?
I think Mr. Mitchell has completed
When did he
submission.
last?
But he has completed his submission. I don't think I have any further right
in-laws
of
house.
submission.
For what, 1.5 years?
I don't think he
Now
has further
suddenly
rights of submission.
At an
Let
identity
him
order,
make
he'll
a
start
submission, let him not
deciding there.
But then there is no end to this.
From January, he
There is no
has
end to this. But absolutely
suddenly
wrong
by the
statement.
identity order, he'll start deciding.
Absolutely wrong statement.
He was deciding there.
He has not stated, he has shown himself that in September also, Malad, I have been prevented. And he's keeping on harping on January. He himself has said so.
His LinkedIn page, based in Bangalore. Now it was a
Malad, I
permanent
have
stay.
been work in Bangalore. Why will I not have it?
Yes.
Malad,
Yes. Anything else?
these are my submissions.
2000 in judgment.
Learned advocates for the parties represented. This application is filed by the.
I think we've disturbed my lord enough. On the last day, I will take my lord's kind leave.
Now relax and enjoy the weekend.
Now it's my lord's, the ball is my
Now
lord's.
relax, enjoy the weekend and enjoy the holidays.
Same to my lord. My lord should have a nice holiday.
Learned advocates for the parties represented. This application is filed by the plaintiff petitioner with a prayer for restraining their respondents and their main agents and assigns and subordinates from denying ingress, egress, and or entry to the petitioners and their family members' incomes, and from disturbing the right of residents and achieve possession in the said two rooms on the first floor of the CL block property and using the entire building CL block or fully described in Schedule A1 is the contention of the petitioners that pursuant to the order passed by this court on 6th February 2026 and affirmed by the Honorable Division Bench in appeal, the defendants are restraining entry of the plaintiff into two rooms of the suit premises. Two rooms on the first floor of the suit premises. It is further contended that on 16th May 2026, the petitioner's plaintiffs came to learn through common friends and acquaintance that there are two rooms in the said joint family house at CL 198, Sector 2, Salt Lake, Kolkata 7,91,000 had been unlawfully and forcibly broken open without the petitioner's consent and knowledge. Stop. It is further contended that the petitioners have serious apprehension that their belongings lying therein, including gold, jewelries, important personal documents, have been removed. Mr. Rai, learned counsel for the petitioner's plaintiffs, draws attention to the complaint made before the police authority. Mr. Roy further draws attention to the order dated 8/9/2025 passed by Learned Civil Judge Junior Division, Vidhannagar North 24 Parganas, in case number 272 of 2025, where it is observed that both the plaintiffs and the defendants are in possession, although the said suit was filed by the defendants of this suit for restraining the plaintiffs of this suit from entering the two rooms of the first floor of the suit property. Although in the said suit, it was claimed that the plaintiffs of the instant suit are in possession as licensee, but the fact of possession is admitted. It is also the case of the plaintiff that the defendants are not permitting the plaintiffs to enter into the two rooms on and from September 2025. Mr. Mitro, learned counsel for defendant number 2, submits that the order passed by this court on 6th February 2026 was with regard to restraint of the defendants from alienating the suit properties or parting with suit properties and or from withdrawing any sum from joint family property. Nowhere in the said order the defendants were restrained from disturbing the possession of the plaintiff in the suit property. Mr. Mitro also refers to an order passed by the learned court has directed maintenance of status quo on the suit property. In PS number 559, the learned Second Court of Civil Judge Senior Division at Parashat has directed maintenance of status quo with regard to the suit property. Mr. Mitro also relies upon the decision of Concord Cooperative Housing Society Limited versus M. Prabhakar and others, reported in 2011 5 SCC 607, and decision of India Household and Healthcare Limited versus LG Household and Healthcare Limited, reported in 2007 5 SCC 510. Learned advocate for Mr. Mitra further submits, as the plaintiff did not pray for recovery of possession in the suit, at this stage the plaintiff cannot by an interlocutory application claim status quo from disturbing possession of 2 rooms in the suit property. Learned advocate appearing for defendant number 1 and 4 submits that the matter that in order to prevent disturbance in the suit property, it is necessary to restrain the plaintiff from entering the same. Upon considering the facts of the case and upon hearing the learned advocates and considering the nature of the suit, it appears that the plaint case did not deal with any dispute with regard to disturbance of the possession, and simply there was a mere allegation that the plaintiff was being restrained to enter and use the 2 rooms of the first floor of the suit property. Stop. There is no documents to show that the plaintiff was ousted from the suit property. Stop. Merely preventing an entry into the suit property does not mean that the possession of a property is already taken away from the said person. Considering the order of the learned Civil Judge Junior Division Bidhannagar, North 24 Parganas, in TS 272 of 2025. It appears that the plaintiffs are in possession of the 2 rooms of the suit property at the first floor, although prevented by the security to enter into the said rooms. It is submitted by learned advocates for the defendants that an affidavit be granted, an opportunity to file affidavit be granted, and at present not to permit the plaintiffs to enter into the suit property, as the same would cause breach of peace in the said property, and the defendants will suffer irreparable loss and injury. Upon considering the facts that right to reside and use a property is a basic right, a person's right to entry in a property during the pendency of a suit cannot be infringed. Thus, the party who has some possession in a particular suit property should be permitted to use the property till disposal of the suit with certain restrictions. Considering the arguments of the learned advocates and the facts of the case, this court is of the view that the plaintiffs petitioners may be permitted to enter into the suit property with certain restrictions. Thus, the plaintiffs shall intimate. Acha, stop. However, in order to ascertain as to whether the allegations of the plaintiff made in paragraph 17 of this application as correct or not, it is necessary to appoint a special officer to cause an inquiry in this regard. Learned special officer shall cause an inquiry in the suit property, mainly the 2 rooms of the first floor, and ascertain as to whether the allegations made in paragraph 17 of the petition is correct or not. The learned special officer shall, upon causing the inquiry, submit report to this court. The plaintiff's petitioner, the learned special officer, upon notice to the parties and their learned advocates, shall conduct the inquiry, and the parties will be entitled to remain present on the date fixed. On the date of inquiry, the plaintiff petitioner shall be permitted to enter into any of the rooms of the suit property, and such point shall be recorded by the learned special officer. It shall also be stated as to how many days the plaintiff is going to reside in the said 2 rooms till the matter is not taken up, till the matter is taken up for further hearing. During the period of stay in the 2 rooms of the suit property, the plaintiff's petitioners shall not cause any disturbance or annoyance. And the presence of the parties and their learned advocates, and the date when the plaintiff petitioner will be entering the suit property shall be recorded by the learned special officer. The police authority during that said period shall also ensure that there is no breach of peace. The facts and circumstances, let there be an order as the plaintiff petitioner will be entering the rooms in presence of the special officer. At this stage, an order mentioned in prayer A of the notice of motion is not necessary.
But my lord,
Yes.
once I'm put in position and once I stay, my lord, they would not prevent the ingress and egress.
Necessary. However, there shall be, in the meantime, there shall be an ad interim order in terms of prayer A for a period of 3 weeks. Period of 4 weeks.
4 weeks, my lord, yes, my lord. Position, my lord.
Let the affidavit in opposition be filed within 1 week after vacation.
Yes, ma'am.
1 week thereafter.
Reply within 4 days thereafter, 1 week thereafter.
It
Let
takes some
this
time to
matter appear on 19
June
6, 2026.
on the top.
That interim order, instead of 4 weeks, I'm making it 5 weeks.
But I'm praying for a stay of this order because they have not been in possession, and the vacations are around the corner. This is the last day of court.
Yes, what do you say with
Your
regard
Lordship,
to
a
stay?
limited stay.
Your lordship has a final
Limited
say.
stay, my lord, so that we can.
My lord, if they ask for stay, I'm opposing, my lord. Now it's on your lordship.
Your Lordship,
Your
last
lordship
day of
already
court.
expressed your lordship's mind. Now they're asking for
Last
stay,
day
my
of
lord.
court, Lordship is passing order. I would be,
What
we
do you
would
mean,
be
the
taking
last day of
steps.
court and 1 day before the last day of
Yes,
court.
Okay, prayer
Limited stay.
for stay I'm granting for a limited period.
It's the vacation. It's the vacation. Well, they are not there. Well, I shall. Well, I may. Well, Lordship will give a limited.
This order shall remain state for a period of 1 week.
Well, 2 weeks, Lordship.
Kindly, my lord, this is
2
not.
weeks. Well, these vacations are going on.
No.
By your lordship, my
1
lord.
week is sufficient.
Well, there will be the advocates will not be there.
Granted special officer shall visit the suit property after 1 week.
Well, after 2 weeks. Well, Lordship may give
my
me.
lord, this is.
Well, it's vacation. The advocates are not there.
My lord, now.
Well, the advocates are not there. Lordship may kindly appreciate this. Well, the advocates are not there. Well, some time may be given to at least prepare ourselves. Well, it is 2 weeks. Well,
Vacation.
Well, we are not there. Well, we are not there. Well, we will be abroad.
What can be done?
No, my lord.
If a lordship could, well, at a limited time, 2 weeks. Well, if a lordship could kindly, 2 weeks. Well, 2 weeks. Well,
6 is the first vacation.
Instead of 1 week, kindly makes it
1 week ছাড়া ওটাকে করে দিন ওটাকে 10 days করে দিন ঠিক আছে
So it's the same thing because well,
26, well, make it till 26. Or it will not
6 is the first vacation.
Yes,
Right?
let them move.
Well, we are not there. If your lordship
Well,
could kindly appreciate
God,
this.
humility, my lord, I say.
Well, they have not been in possession for some time now.
question is you see so some reasonable opportunity has to be
Well,
granted.
That is all. Well, that is all that I am seeking. Well, if your lordship grants me 2 weeks. Well, 20 days. Well, till 9th of June is the vacation.
Then I don't have a say.
Well, I am only beseeching your lordship. 10 days. Well, 10 days will be same. Well, the advocates are out of station. Well, we will not be able to prepare.
You have to prepare in exigency. You have to prepare.
This is something which is. Then there is no reason for the order to be passed, my lord.
No. You see, in case of exigency, councils have to make themselves available. Okay.
Faithful, my lord.
The vacation time, everyone has got their plans from.
Very well. Now you have to get.
They can get someone else, my lord. With humility, I say now. My lord, they have changed the advocate because of that, my lord. Now, this is not fair.
Vacation, that is all.
I could have refused. I have granted you some reasonable opportunity. Please don't make any further prayer.
And I'm also humbly paying, let it be 3 days then. My lord, what is this? I'm not saying anything.
10 days, as your lordship has provided for 10 days and if you apply it, your lordship could just consider extending it by 3 more days.
My lord, I'm asking for a reduction of 3 days.
No.
I'm asking for a reduction of
I've
3 days.
considered now. No further extension.
Grateful.
Yes. Next item 2. Anyone? Both sides present. Okay. After vacation.
Only 2 matters, my lord. Won't take much of your lordships. My lord, on the last occasion, your lordship has recorded there was, my lord, an aspersion that there is terms of settlement. Nothing at all.
Anyway, see, now it is 21. Okay.
I will request your lordship to, my lord, fix a date where arguments can be commenced.
Acha, দুটোতে লিখে নিন.
But, my lord, I must make one submission.
Let this matter appear on 12/6/2026.
Lord, I have one humble submission. My lord, in the first matter, I am there in both the 2 matters. In the first matter, my lord, no settlement, nothing. I wrote to them. They have not replied. It will be, my lord, under the heading for arguments, and I'll commence my arguments. I'm not standing in the way of settlement. My lord, clients are octogenarians.
Anyway,
Bata is occupying, not paying for 10 years.
Let them take an opportunity during
This
this
opportunity given by your lordship. And my lord, in the
So I have to probably I have directed to produce some documents.
Yes, nothing produced.
Is there any documents?
Nothing at all. I wrote to them.
So on the next day, if you don't produce any documents, matter will proceed.
And my lord, next matter, appeal court's order. Your lordship must see this. Let me see.
Yes.
Lordship,
But,
item number 3, I'm appearing for the
Lord,
plaintiff
the
and led by
it's an
Mr.
annual
Joydeep
matter.
Kaur, senior advocate.
Yes. Lord, you have preferred a
Kindly
appeal to your lordship's
adjourn.
order. Yes. Kindly have a look at paragraph 17. I just to show 2 paragraphs, my lord. Lord, Andrew is, my lord, the respondent. My lord, the 2 orders dated
What
May.
is the order?
Kindly have a look at paragraph 17.
Paragraph 6. Anyway, come after this thing.
I will. But
Lordship,
lord,
kindly-
nothing remains in the contempt after this.
Lordship,
I'll
kindly
close
keep
the
the
order
matter after vacation.
Okay, I'm just making it not today. I shall pass
Lord,
necessary order.
kindly pass an order. I have
Lordship,
formally
today is the
given
last
this to your
date and
lordship.
Mr. Kaur needs
Lord,
to show some
everything is
laws on
online,
this point.
recorded there.
Other sides are not here. Okay, after it is here.
I am only
No,
saying kindly
no.
record. I've given you.
I am led by Mr. Joydeep Kaur. He can
On the prayer of learned advocate for the petitioner, the matter stands adjourned
I'm
till
not. I've given your lordship the division.
12/6/2026. Let the copy of the order of the division bench file be kept with the record.
I'm deeply and happy vacation.